Welcome to Sidebar in the Sunshine State with Adam Pollack.
Hey everyone, welcome into an all-new episode of Sidebar in the Sunshine State with Adam Pollack. I'm your host, Mike Leon. Adam is a board-certified criminal trial lawyer based out in Orlando who represents clients all throughout the state of Florida. And for most people, that first court appearance is their first glimpse into the criminal justice system, and it can be confusing. And Adam's going to break that down in today's episode because we're going to look at what happens during that first appearance and what defendants and their families should expect from that first appearance. Adam, it's good to see you as always. Let's start here at this high level. What is the purpose of that first appearance in Florida's criminal court process?
Thank you, Mike. Thank you for having me. Great question. It's a scary time for people, especially if they've never been arrested before. There is a lot going on, and it's important to understand what's happening. So you've been arrested, and you've been taken down to the jail, and then within 24 hours, you are theoretically supposed to be seeing a judge, a neutral magistrate. And what is the purpose of this? It's called the initial appearance, and it's there to ensure that the reason you're in jail is a valid reason. So when you get arrested, you'll have an opportunity to either immediately get out of jail by posting bond, or you'll have to see an initial appearance judge who will then decide whether or not there is something called probable cause to decide whether or not to hold you in jail and to assign you a bail bond. And this process happens super quick. You'd be amazed. By the time you realize you're in court, you're already being taken out of court. It's literally, for most defendants, it's about a 30-second process. The judge has sat back and read the police reports before you even got into court most times. And you get up and the judge will say either I find probable cause or I don't find probable cause. Or in some instances, the judge will ask for the prosecutor and the defense attorney to give their input into whether probable cause should be found and also decide what bail and what release restrictions to give you.
So, Adam, the process is real quick, but how soon after the arrest does that appearance usually take place?
So you are supposed to be seen by a judge within 24 hours in the state of Florida. That's called the initial appearance proceedings. It'll usually be done. Most days now we've switched to doing video. Some courts are still doing in person, so it could happen either way. Either it's going to be in person or a video. You're going to stand up before the judge. The judge will inquire as to your name and inform you why you were arrested, and inform you whether or not that the judge found that there was legal reason to justify the arrest. There's not going to be any evidence provided. The judge is just looking at the police report, and if the police report, states enough that if true was a crime, the judge will find probable cause. So it's a very, very low standard. It's not a finding of guilt, and you're not required to say anything in that proceeding.
Yeah. And let's talk about who's in that proceeding, like who's actually in the courtroom. Can you kind of break down all the officials present? Obviously, you mentioned the judge, the defendant, but I'm sure there's a prosecutor, there's a public defender that if you can't afford an attorney,
Right.
what do each of them do at each interval?
So uh, there is a judge, there is a prosecutor, and there's usually a public defender who's been assigned to the courtroom that day. The judge many times will temporarily appoint a public defender to represent you because you don't have your lawyer present or you requested an attorney, and the judge finds you to qualify. And so the prosecutor is there to inform the court of what your background is, whether you have any prior record, what victim input as to whether you should be released or not, or what conditions of release. And your defense attorney, usually the public defender, but people who are able to have private counsel there will want to have that advantage because the private lawyer will be able to step up and tell the judge, hey, probable cause should not be found for these reasons, or if you're going to find probable cause not for this charge, but maybe for something lesser, and also what type of person you are and what conditions of bail would be appropriate.
Yeah. Some people, Adam, I'm sure are surprised to hear that charges can change early on. What kind of adjustments or clarifications to the charges can happen in that first appearance?
Well, in the first appearance, charges typically are not going to be changed. They're not going to be enhanced or decreased. Where the changes actually happen is after the prosecutor has had a chance to review the police reports and receive more evidence potentially, the prosecutor may change the initial charge you were arrested on, either increasing it, adding more charges, taking away charges, or dropping the case completely. The initial appearance is a very quick, rapid response by the court system to deal with an incident that took place the day before. And so that is typically what initial appearances serve as. In the other instance, where a warrant already been issued for your arrest, that means there's been time for people to investigate. That changes things a little bit around, but the vast majority of people who have initial appearances are usually because they've been arrested the day before and they're seeing the judge for the first time.
And for family members that are listening to this, a lot of the times, obviously, family wants to help. What would you advise them to do in terms of things they could bring? Maybe be prepared to provide if they're going to attend this first appearance to support someone.
So, you know, someone that's been arrested, may want to have a family member there just to show the judge that there's support for the individual, that they're not being released back into the community with no safety nets, so to speak. The family member may step up and say, "Yes, they can stay with me. That's not an issue." Or they can step up and say, "No, this person should not have been arrested. This was a mistake, and I didn't want this person to be arrested." We see that a lot of times in the domestic situation. People are having an argument and it gets heated, and so the police get called for whatever reason, and one person feels pressured into agreeing that they were the victim of a crime, and they really weren't a victim of a crime, and that's their opportunity to tell the judge, "No, no, this is a big mistake. Please release my spouse, please release my boyfriend, girlfriend back home. This is not an issue. And I'm not afraid for my safety." Other times, people are coming to court to let them know that they have some type of mental health problem, and the judge needs to be aware of that.
For the defendants out there, we touched on it about being assigned a public defender, but let's say they already have a private attorney. What role does that lawyer play in the initial hearing outside of what the public defender would do, having your own attorney and representation?
Look, public defenders are great individuals. They're attorneys just like me. I was a public defender at one point. The difference is that if I'm at an initial appearance hearing, I typically only have one client that I have to worry about at the initial appearance hearing. Whereas the public defender, if 100 people are arrested the day before, 99 of those people are the public defender's clients, probably. And so the amount of time and resources that can be dedicated to each individual, it just isn't the same. The amount of care that I can give to a client and the amount of time, which is really the important thing, the time to listen, the time to do the legwork, that's the big difference between having a private counsel and a public defender at your initial appearance hearing.
Adam, for folks out there listening to this, now the hearing is over. What are the next steps in the case and the most important deadlines that they should know about and be aware about?
Okay, so most people are not going to have a lawyer at their initial appearance hearing. So the first thing they need to do is they need to start looking for an attorney. And don't worry, you're going to be contacted by a lot of attorneys, including myself, looking to have you as a client. It's important for you to thoroughly investigate who you decide to hire and to do that hiring sooner rather than later, because we can do a lot of things to help your case along. But important deadlines. You need to not miss your next court date. You need to make sure that if you bailed out with a bail bondsman, that you maintain good contact with your bail bondsman, because they're going to be informed of when your next court date is. You also need to pay attention to any conditions that the judge placed on your freedom. So the last thing you want to do is post bail and then 2 days later be brought back in jail because you violated a condition of bond. It's a common condition of bond maybe to have no contact with somebody, and you can't have contact even if they want to have contact with you. You have to make sure you abide by the conditions of bail.
Yeah. Adam, thanks for the time today on this topic. I truly appreciate it.
Thank you. I really appreciate the opportunity to educate the public.
And that's it for today's episode of Sidebar in the Sunshine State with Adam Pollack. If you want to learn more about the work that Adam is doing defending clients across the state of Florida, do me a favor right now. Visit orl-law.com. Don't forget to like, subscribe, leave a review, and comment or share the episode with someone who needs to hear it. I'm Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.